A woman with Down syndrome has lost a Court of Appeal challenge over late-stage abortions for fetuses with certain medical conditions. Heidi Crowther brought the case alongside Moira Lee Wilson, whose son also has Down syndrome, arguing the law stigmatises disabled people and is discriminatory. The current law allows for pregnancy terminations up to birth for fetuses with Down syndrome and other medical conditions. The judges said the Act did not interfere with the rights of the living disabled. And the case prompts an important question. Should the rights of one group affect a woman's right to an abortion? I am joined in the studio by journalist and author Ella Whelan. So, Ella, this is obviously a very sensitive area. Would you like to talk us through what has happened with this case and how it came about?
Yes, so Heidi Crowther and the group that she works with, as well as Moira Lee Wilson, previously brought a case to try and... essentially, what they want to do is highlight the fact that, as they see it, the current abortion law is discriminatory because women can access abortion for up to 24 weeks under certain circumstances. People always forget that it's under certain circumstances. Mm-hmm. You essentially have to prove that your life is at risk or that you're going to go mad to have an abortion, and you have to convince 2 doctors. But anyway, you can do that for up to 24 weeks. But if your pregnancy involves a diagnosis of Down syndrome, then there is the possibility for you to make that decision to have an abortion later on. And, you know, lots of women who don't get the proper testing done can find out later on that that's the case with their pregnancy, or indeed change their mind. And as Crowther and the people bringing the case with her see it, this is not just something that upsets them, but it's something that is detrimental to their human rights. We're talking about the language of human rights here. As I see it, as someone who thinks that women's freedom is a kind of an indivisible freedom, this is, quite frankly, one of the most pernicious attacks on women's reproductive rights and reproductive freedom. It's using and weaponising the language of rights to try and suppress women's bodily autonomy, because if Crowther was successful in her case, thankfully she hasn't been, what would happen is that women would be restricted from making that decision to have an abortion in cases of diagnoses of Down syndrome. That is, interfering in a woman's life in a way that I think is the kind of a sympathy for that kind of view is really lacking.
I suppose Crowther's point, though, is that, the unborn child or fetus, if it has Down syndrome, is treated differently from the unborn child that doesn't. And that implies a kind of a lower class status for a Down syndrome individual than someone who doesn't have that condition. Well,
there's 2 things to say on that. Number one, if you do get a diagnosis like that, I don't think anyone can know how they're going to react and how they're going to feel until they're in that situation. And I personally would never be able to judge a woman who was in that situation on whatever decision she would make. You know, having a child with Down syndrome is a joy. It can also be a great challenge. And I think that has to be taken into account. But the second, more important point is, if it is the case that these campaigners believe there is a discrepancy, well, I have the answer for them. It's to decriminalise abortion completely, to mean that there are no restrictions and no discrepancies between what is and isn't allowed for a woman to make a decision, and to just say that actually all decisions are worthy in a woman's kind of aspect of looking at the future of her life, whether that be maybe it's because her and her partner have broken up. Maybe it's because there's been a diagnosis. Maybe it's because something has drastically changed in her life that means that she can't continue this pregnancy. Once we get in, I think, there is a sort of... I don't agree with Crowther's campaign, but there is a point to be made that once we get into saying that there are good and bad reasons for having an abortion, you're interfering in the very private moment of a woman's life in a way that I don't think the law should.
Isn't part of her case the concern about late-stage abortions, that actually you're talking about aborting by this point, a sort of fully formed individual? Does that worry you at all, when it becomes so late-stage that there's very little distinction between the baby in the womb and out of the womb?
Well, I think we have to be really careful about the language we use, because, talking about the idea of a fully formed individual, I mean, we do make a distinction between a pregnancy, which is, a fetus attached, which, if you're having a wanted pregnancy, is a baby from the get-go. I've just had a baby, and, when I was 4 weeks pregnant, I was thinking about what it would be like as a fully formed individual. But until somebody is a member of society, you know, as the court used the term a living human, then we make a distinction between that and a pregnancy, which is...
So your distinction is birth?
Which is a pregnancy is still intrinsically part of a woman's body, and therefore the woman's rights and beliefs and desires and freedoms come first. But just on the issue of late-term abortions, there's a callousness to all of this, which Heidi Crowther talked about the fact that the court doesn't take into account her feelings and has upset her, and I'm sure that's absolutely true, and I really feel for her. I wish somebody would convince her that actually women who are making the decision to have an abortion on the basis of a Down syndrome diagnosis don't devalue her at all and want her to, and would love and support her to have the best life possible. And I wish someone would explain that to her, because it's heartbreaking seeing her go through so much pain and suffering on the basis of this when she doesn't have to. But on late-term abortions, one, they're so rare, and two, what a woman has to go through to have a late-term abortion is, I can't explain how awful it must be. I mean, I think you only really realise it when you've been heavily pregnant yourself, what that entails. I won't go into what it entails medically, but you can imagine making that decision. Women don't do it lightly, and I just would like people to try and get into the frame of mind of someone who is having to make that decision. They're not doing it because it's a Tuesday and they fancy it, although I think that they in law that they should be allowed to. Women aren't that callous. They're not that sort of flippant. I think that we devalue the importance of women's agency and the decisions that they make and why they make them, particularly at the very few women who make them at that late stage.
But again, I mean, from what you describe, it's very clear that a lot of emotions are invested on all sides of this debate. And actually, when it comes to these sensitive topics, isn't it quite a good step forward to try and bring the emotions out of it and talk about, to be able to have these discussions, particularly when it comes to clashes of rights, or at least perceived clashes of rights?
Yeah, absolutely. And, you know, there's one of the things about abortion is that it's obviously a very personal thing, because we're talking about women's personal private decisions. That's why I think it shouldn't be anything to do with any kind of legal framework. It should just be regulated on the basis of normal medical procedures, you know, safe and all the rest of it, in the same way that heart surgery is regulated or whatever. But because it is still a moral political conundrum, because we are still... I mean, abortion is technically illegal in this country. Everybody forgets that. We just have this workaround, which is the 1967 Act that says that, you know, on this basis, a doctor can be protected from being prosecuted. We don't have... Women's bodily autonomy is not a legal right in this country. But to take all the emotions out of it, you have to understand that those emotions are the sole property of the woman. And then actually, and this is the point I made on Twitter that has upset lots of people in Heidi Crowther's campaign, other people's emotions and feelings are irrelevant. The judges ruled that though they understood why Crowther and others who were part of her campaign felt upset, that this was actually it wasn't relevant to a woman's decision to have an abortion, because why would you lay the magnitude of the question of disability rights at the feet of an individual woman going into a clinic to have a procedure that's not only inhumane, it's also not legally sound. So I think that, you know, we have to be clear that though this is framed in terms of disability rights, it's also there's an element of kind of identity politics here and competing rights. What this really is an attack on women's bodily autonomy. And lots of these campaigners, as it happens, even though they talk about being really against late-term abortions, also campaign against tests that women can have earlier. I mean, medical sciences and innovation has meant that tests are now readily available much earlier in a woman's pregnancy to be able to get these kind of diagnoses. So if you're upset about late-term abortions, why not allow those kind of tests early on? But of course, they're not in favour of that. So however way you look, women are hamstrung. And I think that actually this ruling, though it might seem cruel to some people, is very important for women's freedom. And I think we need to actually push it further and say that these kind of anti-choice attacks on women's bodily autonomy and abortion can't be allowed to take the shape of sort of identity politics, the language of rights, because in its kind of naked form, it's an attempt to try and suppress women's freedom, and we should push back on that.